Listen to me, I'm talking. I'm assuming you graduated from high school, right?
8th grade.
You went through 8th grade.
If there's evidence provided against me, I have a right to defend myself using that very same.
That wasn't the question I asked you.
That's
you do have a right to defend yourself, Mr. Raymer. I'm just
my right for violence.
I'm talking, you're not. If you don't stop talking and listen to me so I can go through my speech, I will send you over to the jail.
You're the one that signed the warrant for my arrest while I was in jail.
I don't know that. I don't remember.
Yes, you did do that.
Okay. I'm allowed to do that.
No, you violated my rights.
Okay.
I'm not going to take any of the attorneys from here because they're all corrupt.
In the matter of the people of the state of Michigan versus Shane Leroy Raymer, this is the date and time set for a final pretrial conference. Today was the motion deadline for both motions and motion in limines to be heard. Jury instructions were to be provided to the court by April 2nd, along with any proposed voir dire questions. We are set for trial on April 22nd of 2025. Mr. Raymer, you are charged with police officer resisting and obstructing causing injury, which carries a maximum penalty of up to 4 years in prison. Police officer assaulting, resisting, and obstructing, that carries up to 2 years in prison. There's 2 of those. And then there's a disorderly. And what is the plea offer in this file?
Your Honor, the people have offered to a plea of 2 counts to attempted R&O.
All right.
So 2 misdemeanors, and we would kill a brute to no upfront jail.
All right. Mr. Raymer, the plea offer in this case was to plead to 2 one-year misdemeanors with no upfront jail, and there'd be like 12 months or so of probation, some minimal fines and costs. Do you understand that? All right. Now, Mr. Raymer, you know, I'm assuming you graduated from high school, right?
8th grade.
You went through 8th grade, and this is a felony that could result in you going to prison. Why don't you stand in front of that podium for me? So do you understand an attorney can help guide you through the legal process?
Yes, I tried to have, I almost had a public defender. Unfortunately, she wasn't representing me appropriately. I'd asked for another one, but.
So I have no authority over who gets appointed. You're appointed an attorney.
I understand that, but when they're not representing you appropriately.
Okay, I didn't ask that. I'm just saying you have a right to an attorney. I know the attorney you're referring to. She's diligent. She works hard. Maybe you didn't like, I know when I was a public defender, sometimes my clients didn't like what listen to me, I'm talking. My clients didn't like the things that I told them. But, you know, her job isn't to do what you want. Her job is to represent the law. So you understand at this point, you can hire an attorney, or you can go with the public defender and whoever they assign you, or you can go to trial pro per with no law degree, no experience, and risk going to prison. You're going to represent yourself.
I'm going to represent I ain't got no choice but to
Have you provided your jury question, the voir dire questions? Because if you haven't, they're waived.
If there's
no, they were due.
If there's evidence provided against me, I have a right to defend myself using that very same.
That wasn't the question I asked you.
That's
you do have a right to defend yourself, Mr. Raymer. I'm just
my right for violence.
I'm talking, you're not. If you don't stop talking and listen to me so I can go through my speech, I will send you over to the jail. Do you understand? All right. You have not filed any motions. Jury instructions were due and voir dire questions were due. You have not provided those. We gave you a copy of this. So do you understand what I've received is what will be used? Yes or no?
I will be allowed to ask my questions.
What question?
When I'm cross-examining, I will get my.
I'm talking about juror question. I'm talking about jury instructions and voir dire questions. You understand now? You didn't file, listen. I know, but you waived that because you have not provided them. Do you understand that? Do you understand that?
No, I don't.
Okay.
I didn't understand that.
Okay. Well, I can't advise you of the law because I'm not an attorney. I'm a judge.
No, but you're looking at the case and you've been presiding over my case for 3 years now.
I know. It's fine. You're going to go to trial.
You're the one that signed the warrant for my arrest while I was in jail.
I don't know that. I don't remember.
Yes, you did do that.
Okay. I'm allowed to do that.
No, you violated my rights.
Okay. Well, you have options. You can file a complaint with the JTC if you'd like. So are you prepared to go to trial?
Absolutely.
Have you provided your witness list?
I haven't yet, but I will.
Okay, that was due.
My witness list was provided when Ms. Underwood was my attorney.
Okay.
And my witness list is.
Have you subpoenaed any witnesses that were not on the prosecutor's raised just eyewitness list?
Yes, my witnesses are the ones that was there at the scene.
No.
And, yes.
Do you understand that you have to provide a witness list and you have to provide a copy to the prosecutor? Do you understand that?
Prosecutor, I gotta provide what to him?
So if you're gonna have witnesses at trial, you need to make sure the prosecutor has their name and contact information so that they could interview them prior to trial if they wanted. Do you understand
Well,
that?
they got all that information.
They do?
Yes.
Okay,
Yeah,
so,
my witnesses are my parents and my aunt.
okay, I don't know, are those on, if they're not on the people's witness?
Curtis,
I'm not
Benny,
sure.
Okay,
and Rose.
if you haven't provided a witness list and they're not on the people's list, you understand you won't be able to call them.
Okay, I will provide the information. I
Okay.
did provide that information. Yeah.
I'm just telling you. So you need to make sure that there's a witness list in the file that was provided to the people.
So I gotta re-provide it.
I don't know. Go back and look at what
I'll
witness
just-
list
I'll
has
just
been
do that
filed,
next week.
their name, their contact information. And then any subpoenas you have to do, if you have to subpoena anybody to be present, you need to get those filed this week. And then the court signs them and then you serve those people with those. Do you understand? Now, do you understand when we go to trial, a lot of times some of the questions you ask or he asks may be objected to, and it's not personal, it's just, we have to follow the law.
Yeah.
Okay,
I'm allowed to object to though, right?
huh?
I'm allowed to object to.
You are, and then you have to provide the basis for that objection. Okay, so you need to understand your objections. So you might want to do some research to understand.
I've been doing.
Good, good. You sure you don't want a public defender for trial?
Huh?
You sure you don't want an attorney for trial?
I'm not gonna take any of the attorneys from here because they're all corrupt.
This case was a perfect reminder that confidence alone doesn't win in court. Facts, evidence, and understanding the law do. Whether you think the judge was fair, too harsh, or gave this defendant every opportunity possible, one thing is certain. The decisions made inside a courtroom can change a person's life forever. Now, I want to hear from you. If you were sitting in that courtroom, what would your verdict be? Did the defendant make a fatal mistake by representing himself, or do you think he had a point? Let me know in the comments below because I read every single one. Now, we move on to our next hearing.
Cause number 2020-562, announcement of council, please.
David Nunez for the state, Your Honor. State is ready.
And Daniel Avalar for Elizabeth Medina. She is a present judge in my office. She's healthy, Judge. She works here in our office, Judge.
Yes, I think I remember this case.
Yes,
Okay,
ma'am.
Ms. Medina, how are you today?
I'm good, Judge. How are you?
Good, I'm good, thank you. Okay, what are we doing in this case?
Your Honor, the defense filed a motion to modify the PR bond conditions, Your Honor. Specifically, we're
Hang on.
asking that yes, ma'am.
Hold on a second. He has a PR bond. Did you know that? She's on my list. Did you know that, Mr. Avila? I'm looking for it.
On the naughty list or the nice list?
Naughty. I only get naughty. Let me see. Conditions included monthly reporting to obtain. Ms. Medina has been compliant. She's tested 6 times a day. Why do they write me to tell me she's compliant to scare Mr. Avelar?
I just had a heart attack and I looked at her right now and she says, I don't know what they're talking about.
Mr. Medina is aware. No, I've told him specifically to put down when they don't behave, but she's
Right.
and behaving, but she's on the naughty list. Okay, go ahead. So we're good. We're good, Ms. Medina. We're good. Talk to me.
I was like, oh my God, no, don't tell me.
No. We're good. We're good. Okay. Mr. Arms. Go ahead.
Thank you, Judge. So we respectfully filed a motion. We're respectfully asking the court that it change the conditions specifically from the mobile unit that she's on right now to the ignition interlock, Your Honor. Miss Medina is a single mother. She's an assistant here at Wyatt Underwood. She receives about a little over $100 in child support, Judge. And then she has the income from here, Judge. She pays a total of, I think, $180 per month on this unit. And she got a quote for the interlock, and it's going to go down to maybe like $80. So it's about it would reduce her monthly cost to $80, Judge. In support of our motion, Judge, and in connection with that, you almost gave me a heart attack. She has been compliant with Her Honor's conditions, I think, since at least February of this year, Your Honor.
It's placed on a split bond. I was going to ask.
So it's yes, Your Honor.
Okay, she's been on it for about 7.5 months.
Right.
Okay.
What do you think, Judge?
He's on, see, I want a little bit more of a history. The only thing I can do to give you some relief, instead of the Scram unit, I don't like the other units other than Scram, but she is on Scram right now. She can do Intoxilock or something, a Smart Start that's cheaper. A cheaper mobile unit I will allow. That I will allow. So look into it, find a cheaper mobile unit. If there's any issues, Mr. Avelar, you have to realize she's assuming the responsibility. That's why I don't like those cheaper units. But I'll allow.
Judge, right, is the court talking about history in terms of since she's been on your
I want
order, or
1 year of clean. And she's been on since February. Give me 1 year. I'll let her do a cheaper device 1 year, and then maybe we'll take it off.
so she can go look for a cheaper device and then she'll be governed at the same rate and time?
What do you mean governed at the same rate and time?
So she blows, I think, 6 times a day.
Oh yeah, she's still gonna do that. Still
Right.
gonna do all of that, but it'll be a cheaper device. What's the cheapest device, Mr. Artemio?
Or in-home judge, or
Mobile unit, yeah. What's a cheaper device?
I think the cheapest one and the most reliable one would be Smart Start.
How much is Smart Start?
I think it's like 85, something like that, Judge.
There it is. That's a good little reduction, 85 a month, Smart Start. And I don't mind Smart Start. Smart Start is probably the better, cheaper unit. Okay, your attorney's paying 180, that'll give her, that's almost half price. So let's do the Smart Start unit.
Okay,
Oh.
Judge.
The problem, see, this is the problem, Mr. Avalad, and I don't know if you know this, not only are the cheaper versions of these mobile units not reliable, right? The issue is they may be cheaper, but they charge you for everything. They charge you for a written statement. They charge you if you miss and they have to lock you out. They charge you a fee for reinstatement. They charge you a fee if it's positive. They charge you for a fee. So you have to realize that these cheaper places sometimes don't come out cheaper. For compliant people, maybe it does, right? But for people that are not too compliant, and she's compliant, I don't think we've had any problems with her. So let her do the home unit for a little bit longer, and then we'll revisit this. Okay?
Okay, Judge,
So
yes.
we've given her a good chunk of relief, $100 a month. That's a lot.
And that wraps up today's courtroom hearing. What started as a routine bond modification request quickly turned into a reminder that every decision in court comes down to accountability, compliance, and trust. While the judge wasn't ready to remove the monitoring requirement completely, she did recognize the progress that had been made and offered a solution that could ease some of the financial burden. Now the question is, do you think the judge made the right call? Should compliance for several months have been enough to remove the device entirely? Or was the court right to play it safe and require more time? Let me know your thoughts in the comments below, because I'd love to hear where you stand on this one. If you enjoyed this courtroom breakdown and want more real-life legal stories, surprising judge reactions, and fascinating court decisions, make sure to subscribe and turn on notifications so you never miss a new case. Thanks for watching. Stay safe, stay informed, and remember, one decision can change everything when you're standing before a judge. I'll see you in the next case.